Good. This is being videoed, so I don't want any cat calls or funny sounds in the background. And our speaker this morning is Brian Kavanaugh. And you've heard his introduction. He is a local attorney in the Webster Groves, Kirkwood area. He is a professional and a specialist within the legal profession. He specializes in employment law. I know that he is good because not only have I had a one-on-one with him and kind of determined that this fellow really knows an immense amount about his specialty, but he was very gracious in helping my daughter in Seattle deal with some issues regarding her change of employment and gave her some excellent help and advice. So from a family standpoint, I know that he is not only a really sharp individual in his field, but also is one who is very generous spirited. Brian has his undergraduate from Notre Dame University, and he has his law degree from St. Louis University. He's had big firm experience in the law, in his specialty, and he's also worked for a major nonprofit, or was it a for-profit, an educational institution that he worked for in the field that, again, he specialized in. What I'm excited about in his presentation this morning is for many of us running a small company as independent contractors, it's really important that we know where we stand with regards to the law and in terms of what we have to do if we're employing other people, or as it applies to what we're signing up for as independent contractors. So I know that you're going to enjoy the next 15 or 20 minutes of information from Brian Kavanaugh. Thank you, Brian, for coming this morning.
Thanks, Barry. Well, good morning, all. I wanted to talk to you relatively briefly about independent contractor issues. Independent contractor versus employee misclassification issues. One thing I should make clear, I'm going to be talking a lot about being careful not to classify people as independent contractors who shouldn't be. There's nothing wrong with an independent contractor. There's nothing wrong with that role. There's nothing wrong with that relationship between a company and an independent contractor, as long as it's clear that that's a valid classification. This is a hot topic now. Federal and state governments, governmental agencies are being very proactive. They're forming task forces to investigate these issues and find groups of workers who are misclassified as independent contractors who should be classified as employees. And I'll talk about why they're doing that and the harm involved. So let me throw this number out there, $2.7 billion. That number represents the GAO's 2009 estimate of the amount of federal revenue lost in just 1 year in 2006 due to employee misclassification. So that number explains why the federal government cares about this issue. It's losing billions of dollars every year based on the misclassification. Where does that number come from? Well, as employers and employees, you know that employees and employers pay payroll taxes. Independent contractors don't. The independent contractor relationship doesn't give rise to all those payroll taxes that the employee relationship does. And that means that the governments are not getting all of their tax revenues. So that's why the government cares about this, because they're losing money. And it also hurts employees, but most directly it hurts the government's revenue. So let me give a broad overview. A company pays workers for its services. Very rudimentary issue. Each of those workers is either an employee or an independent contractor. As a practical matter, most workers in the country are employees. Most workers for big companies are employees. But many employers in all sorts of industries, big and small, are classifying workers who should be classified as employees as independent contractors. What are some of the benefits to an employer for doing that? Well, you can see in that red box, an employer can save up to 30% of payroll costs by eliminating employer-side FICA, that's the tax for Social Security and Medicare, FUTA, that's the unemployment tax, and state taxes. So basically, the employer's eliminating those payroll obligations, and they can save a lot of money. They can cut costs, they can cut overhead, they can be more competitive, they can increase their own revenue by doing that. There's other hard costs to a company classifying a worker as an independent contractor. The company doesn't have to pay work comp premiums. The company doesn't have to pay overtime. So you can pay, the company doesn't even have to pay a minimum wage. So some companies are hiring independent contractors, maybe paying them in cash, paying them less than minimum wage. Overtime's an issue too. If you have a worker who's working 50, 60, 70, 80 hours a week and just getting paid straight time or getting paid a flat rate for that and not getting time and a half or overtime, that can result in huge savings for the company. There's other soft costs involved too, not hard costs, but the company is generally protected from employment discrimination suits. You can't say you are a victim of employment discrimination if you weren't an employee in the first place. You can't file a workers' compensation claim if you weren't an employee. So the company doesn't have to pay work comp premiums, and it doesn't have to worry about getting a work comp claim against it. The employee or the worker, if they're not an employee, generally loses collective bargaining rights and loses the right to join a union. So there's a lot of, I guess, shiny, attractive things to an employer for making this classification. As I mentioned before, there's also a competitive advantage. It gives the company the ability to underbid competitors because the employer doesn't have the overhead. Or maybe everyone in this industry, in this locale, is doing it this way. And if this one company wants to play it straight and go by the book, well, they're not going to be able to compete because suddenly they're going to have a lot more overhead than everyone else. This is especially prevalent in the construction and trucking industries. So let me go over again a few things that the misclassified worker loses. Let's say someone should be an employee, they're classified and they're paid and treated like an independent contractor. Well, so what? How does that harm the individual? Well, as I mentioned before, the person loses out on minimum wage rules. They lose out on overtime. They lose out on the ability to get that half time for all time worked over 40 hours in a week. The person loses out on the right to OSHA and state workplace safety rules. Loses out on workers' compensation coverage if that person's injured on the job. Protections against harassment and discrimination. Unemployment benefits. If the person is let go through no fault of their own, if you're an employee, well, it's almost automatic under those circumstances that you would get unemployment benefits to provide a little cushion before your next job. Well, if you're an independent contractor, you don't get unemployment benefits. It's not a legal obligation that a company offer paid sick time or paid vacation time or other health benefits, but most companies do. And if you're an independent contractor, you're not going to be eligible for that. You're not going to generally get health insurance, employer-provided health insurance if you're independent. The person loses the right to organize and bargain collectively for work conditions. The person also loses out on the Social Security and Medicare payments that the portion of that the employer used to make or should be making that now the individual is going to be responsible for. So what's going on? The government knows about this issue and it's aggressively cracking down on this issue. Something a little unusual is that state and federal agencies are working closely together on this issue. Not implying that there's animosity between the states and the feds, but usually they operate pretty independently. Well, here they're working very collaboratively. They're forming task forces together. They're sharing information among themselves. They're really getting the word out to workers. If you're on Twitter and social media, I know I am, and every day I see something from the Missouri Department of Labor, from OSHA, from whatnot, doing a blast to employees to really get the word out that they should be concerned about this and look into this themselves. New laws are being passed over the past few years. The state of Missouri passed a much harsher law. There's bills pending in Congress. There's new laws coming out of Congress that's providing much harsher penalties for this misclassification. Those penalties include criminal penalties under the right circumstances, and also provide the option of, under the right circumstances, the business can be shut down as a penalty for this. The IRS has just put out, within the past month or so, an amnesty program where employers can come forward and convert workers to employees and pay only 10% of the back taxes owed.